Hi everyone, welcome back to Notarized by Cristy, where we break down essential topics you need to know for your Louisiana Notary exam. Today, we're diving into an important subject that every aspiring notary needs to master: donations. Whether you're studying for the exam or just want to brush up on your knowledge, this video is for you. Donations are a key component in Louisiana law, and they come in different forms with specific legal requirements that you must be familiar with as a notary. Let's start with the basics. In Louisiana, we primarily deal with two types of donations: donation inter vivos and donation mortis causa. Donation inter vivos is a donation made during the donor's lifetime, and it takes effect immediately. For this type of donation to be valid, it must be made through an authentic act, which means it has to be notarized and witnessed. Donation mortis causa, on the other hand, is similar to a will. It takes effect only upon the donor's death and can be revoked at any time during the donor's lifetime. These donations are often included in wills and are governed by the same formalities. This is a good note-taking opportunity for you to make in your notarial study guide to help you prepare for the exam. A donation inter vivos has immediate effect and must be made by authentic act. A donation mortis causa takes effect upon death and is revocable during the donor's lifetime. Now let's go into some other key requirements and principles that apply to these donations. One of the most important aspects to remember is that donations must be made by authentic act unless the law provides otherwise. This means that for the donation to be valid, it must be executed in front of a notary and two witnesses. This is crucial for the donation to hold up in court. Additionally, if you're dealing with donations involving immovable property, such as land or a house, the act of donation must include a precise description of the property. Without this, the donation could be considered invalid. Donations can come with conditions. For instance, a donor might specify that a piece of land should only be used for conservation purposes. If the donee, who is the recipient of the donation, fails to meet this condition, the donation can be revoked. This typically requires legal action, so it's important that both parties understand and agree to any conditions attached. Another critical concept is ingratitude. If a donee commits a serious act against the donor, such as a crime, the donor can revoke the donation. This is one of the few situations where a donation inter vivos, which is usually irrevocable, can be undone. Take special note of these additional key points for your studies. Conditions must be lawful and possible. Non-fulfillment can lead to revocation. For ingratitude, grounds for revocation include serious harm or crimes against the donor. Let's not forget about manual gifts. These are donations of movable property that are transferred by actual delivery. For example, handing over a car's keys would count as a manual gift. There's no need for an authentic act here, but delivery and acceptance are crucial. Lastly, we have the concept of usufruct. This allows the donor to give away ownership of a property while retaining the right to use it for a certain period, often for the rest of their life. This is common in donations of immovable property where the donor wishes to continue living on the property. And that wraps up the basics of donations. Remember, as a notary in Louisiana, it's your job to ensure these formalities are followed to the letter. Improper documentation or failure to adhere to legal requirements can result in a donation being declared invalid. I hope this breakdown helps you better understand the fundamentals of donations in Louisiana. If you found this video helpful, be sure to like, subscribe, and hit the notification bell so you never miss an update. Also, feel free to leave your questions in the comments below, and I'll do my best to answer them. Thanks for watching, and I'll see you next time.